Commissioner.
So now, let me not just went into this
Yeah.
unnecessary.
This is not
This is not unnecessary, my lord.
So now
The judicial observation with regards to this, my lord. He should rather apologize to the court.
You said
For misleading, my lord.
it's not unnecessary.
He should rather
but
apologize for misleading.
let us
Yes,
the point.
you have misled that you have been governed by the 18 rules. It is not
And he was
applicable
seeking
to you because
interim on that day.
Under tribal welfare department.
But now, since the legal basis have changed,
Ah.
now the point I am making is that I only on the point that merely a filing of an FIR
Yes, yes.
may result into a suspension or not.
Yes.
That is the argument.
Yes.
So your lordship's my lord yesterday posed a question that
Please go through rule 9.
yes, straight up.
पढ़िए उसको.
Yes. The appointing authority
Yes.
or any authority to
वो point छोड़ दीजिए उस पे clause 2 पे आइए.
clause where a case against him in respect of any criminal offense is under investigation,
Yes.
inquiry, or trial. Now let the proviso, provided that a government servant shall invariably be placed under suspension when a challan for a criminal offense involving corruption or other moral turpitude is filed after sanction of prosecution by the government against him. But because your lordship must know the background, but maybe he's right.
He's right means.
I fairly concede that, sir. I fairly
You say
concede
that it is correct.
he is correct. It is the position is correct.
Yes.
I fairly concede that.
Yes.
Great respect.
Yeah.
But your lordship must know the background, Lord. There is the order to which this whole entire saga will not put out, and we challenged this order before we challenged the investigation. The honorable court.
There are serious allegations against the petitioner also.
Yes, my lord.
Yes, there are.
My lord, they have
What happened was,
annexed the FIR, my lord. May peruse the contents of the FIR. It could not be read in the open court, my lord. My lord, may read it once.
No.
I agree.
Yes,
I
yes.
agree, my lord. But allow me, Milord, please.
Yes,
Because
yes.
I have a case.
Yes, sir, please
To make.
continue.
Milord, please have the order. I have handed over, Milord, with great respect. The order says, Milord, the learned counsel referring to a FIR at crime number 573/2025, registered at PS Rowdy on 15th November 2025 at 17:45. Milord, please mark the timing. Because the
We
honorable.
will not go to the facts of the case.
Yes,
चलिए आप आगे बताइए.
I am father of the victim.
Yes.
I am not the accused. What happened was in absence of my family, my daughter was raped. That's what. I went to the police station to lodge an FIR against the accused on 15 November. On the next day, the accused through her niece, there was a counter blast FIR against my family on a ground that you raped my niece. So, that's the by and large the factual position. Then again on 17th, my family went to the police station and again a FIR was lodged. So I am not going into this since the case
you
is.
say that your FIR was prior to the FIR of the accused.
Yes, first.
My lord, this matter pertains to a dispute regarding service. My lord,
We will not.
these pleadings with regards to there was a counter
We will
FIR.
not go into that,
Yes,
but
good.
let us listen to
Yes,
it.
Just go
criminal
through the
courts.
order sheet, what I have placed before
Yes,
this
please read.
That's the heart of the matter, 573/2025 is the FIR which was registered by me at PS Rowdy on 15 November 2025.
Your FIR number was
573.
570.
Mine. So 2025 registered at PS Rowdy on 15 November 2025 at 5:40. Contains that the father and brother of victim were present at Rowdy along with her to lodge the FIR, whereas next day on 16 November, this is the accused who filed. 16 November 2025, an FIR was lodged against the father and brother of the victim, alleging an incident on 15th November at 5:45, which was registered at crime number 576/2025 with PS Rowdy. Now, this reasoning is very important now. It is not feasible that the father and brother of the victim who were present with her at PS Rowdy could have committed molestation of the complainant in subsequent FIR at the same time at same place, which is 6 kilometers away from PS Rowdy. Now, this please mark, I hope your lordships don't mind it. This is very important.
Yes.
Then after this, the authority, my lord, I received that suspension order merely on the registration of the FIR. And on the very next day, my lord.
Yes, sir. What is the WP 45862?
Yes. It's filed by the victim, my daughter. It's filed by my daughter.
For what?
For we sought appropriate investigation in that petition and inquiry, because what happened was that they were the police officials were forcing us for the settlement of this issue with the respondent accused. Since in both these cases, what has happened cleverly by the respondent is that the FIR was lodged against us by a minor through a niece, as I mentioned, your lordship. So, that is one aspect which I have completed. Now, may I just, your lordship posed a very important question to us with regards to the judgments yesterday, that merely a filing of an FIR can result into a suspension or not. I'm only on that note. If your lordships may just have, we have uploaded, for your lordship's convenience, we have uploaded judgments from the ERP. Paragraph 12. And with great respect, since I am assisting your lordships, there is no direct reasoning I have found with regards to these. There is no direct judgment that mere filing of an FIR, but the reasoning adopted in these judgments are very important. I am only dealing with two judgments, and I leave it to your lordships. If your lordships may just have para 12 of this. In the case of Captain M. Paul Anthony versus Bharat Gold Mines Limited and another, it was held that an exercise of right to suspend an employee may be justified on the facts of a particular case, instances. However, are not rare where officers have been found to be afflicted by suspension syndrome and the employee have been found to be placed under suspension just for nothing. It is their irritability rather than an employee's trivial lapse which has been often resulted in suspension. May I just have the CCS rules? Suspension. The authority appointing or any authority to which it is subordinate or the disciplinary authority or any authority empowered in that behalf by the Governor General or special order may. Since these are the administrative authority, the discretion which has been given to them has to be applied with some application of mind.
Whether the suspending, the person who is suspending has to go into the merits of the case which has been registered.
No. I'm not saying that. The point which I want to project is this.
Yes.
Suppose an administrative authority has been given some, because the word used is may by the legislature.
Yes.
He has been construed with some responsibility.
He has the discretion.
Yes. So,
Considering the facts and circumstances of each case,
Yes.
when there is a serious allegation against you, he has exercised his discretion. Yes.
Yes, that is there. But whether that discretion in what way it has to be exercised, I am not going to that.
Yes,
The lordship knows, my lord.
Yes.
The discretionary part and all that. But my lord, the point, my lord, is that if on the receipt of any information, you suspend him, that is, my lord, at least
It was not a punishment.
No, it's my lord, because what happened was
Stigmatic.
no, my lord. May I just
What my friend is pleading is arguments are correct vis-a-vis if it's with regards to termination. my lord.
suspension is not
Yeah.
automatic to my lord allegations. Suspension is not automatic to allegations, my lord. And my lord, there is
Then what is suspension?
Yes,
You read the law. What is the law then?
but may I just I need what your lordship submitted.
Yes, please.
But your lordship has been over the suspension.
I am only listening to you.
Yes.
अब बताइए ना.
But may I just refer to
Yeah.
But this is the chapter, of further discretion by the authority and how it has to be exercised. I am not reading it.
Yes.
I am not reading it. I am just placing it before your lordships because these are the municipal laws, my lord. And the discretion, how and the manner in which the discretion has to be, my lord, adopted by them or how?
Please come to the relevant point.
Yes. But may I, if your lordships may just have an ERP one case, London Borough versus Lambeth of Forgive. It's a United Kingdom judgment by Royal Courts of Justice. It's not binding upon your lordships, but the reasoning is very important. Please have para 24 of that. This answers what your lordships are putting to me exactly.
Where is it?
It's on ERP minutes, para 24. Whilst views generally might be reasonably differ as to whether suspension is a neutral act, the view of the court is that it is not. In Messi versus South, etc., on 11, my superstone accept that it is perfectly permissible to restrain a dismissal, but he contends that a suspension is a qualitatively different affair. It is, he submits in the skeleton argument, a neutral act preserving the employment relationship. I venture to disagree, at least in relation to the employment of a qualified professional in a function which is a much of a vocation as a job. Suspension changes the status quo from work to no work, and very, very important, and it is inevitably cast a shadow over the employee competence. Of course, this does not mean that he cannot be done,
It cannot
but
be
it is not a neutral act. Indeed, Mr. Superstone goes in his skeleton argument to justify the suspension on the ground that a criticism of the claimant in the most recent report was serious, and she had, I use his word, failed to accept the criticism of her in the two previous reports. Since, my lord, the distinction I have, my lords, already placed before your lordships in the present case, the justification of all this awaits the judgment of disciplinary tribunal. But it seems, I am skipping that. Please have para 26
My lord,
right away.
I apologize. I'm interfering with his arguments. My lord, peruse para 20 of the same judgment before he. What were the allegations, my lord?
But I'll come to that para.
What were the allegations, my lord? Dismiss. Here the allegations are with regards to rape, and the allegations therein he was उसको खींचा है बच्चे को corridor में.
The point.
For one, this judgment is not applicable.
He is only making a
I'm
distinction.
dealing with the reasoning. I'm not saying this is binding on your lordship.
Yes, yes.
Anyways, is not. Please.
Para 26 minutes.
Yes.
A number of initial observations can be made out by Ms. Mulholland letters. First, the decision the husband had apparently been taken on the day the letter was written. Second, it does not indicate by whom the decision was.
Now, these submissions are all factual in
Yes,
the
factual.
particular facts and circumstances
Yes,
of the
yes,
case.
27.
Here in India, we are not required to go
I
into
just-
whether we are required. Show me any judgment where we are required to go into the
But may
merits
I-
of the facts
Please allow
before
me,
suspending.
please allow me just for
Yes.
3 minutes.
Yes.
I'm your lordship's hand.
Really, we have spent more than 10 minutes.
27 and 28 at the end of.
Hmm.
It is well established that a suspension is not to be considered a routine response to the need for investigation if and to the extent that requires authoritative support. Such support is given in this particular context in dealing with the allegations of abuse against the teacher and other staff, statutory guidance for local authority, so and so minutes. Now, please have 28 straight away. If the authority is required in the legal sense, the case of so and so, in that case, the issue was whether the defendant local authority acted reasonably in suspending the claimant from a post as a residential care worker in
Now,
residential.
this is in this paragraph is in pursuant to some
Yes,
guidelines
yes.
framed therein.
Yes,
उसके key points दिए हैं उसके नीचे 27 के नीचे.
yes. That's your lordship is not. That's the heart of the matter. What your lordship is saying, absolutely, but I agree with that. Now, my lord, the point I want to project is this: if the authority has been, if some responsibility has been given to him, it must be that the word used in 9 must be used carefully.
Yes, yes,
Not
he
like
has used
discretion.
carefully. Yes, yes.
Now, I am not
It
saying
is
that I'm not saying that I cannot be suspended at all. But the challan or the sanction must be there. Yesterday also I placed this argument that there are some judgments which are in my favor, some judgments are in their favor. Well, if we look at the language of the statute, it is as clear, not as broad daylight, that the sanction and challan must be there. And I deeply apologize for that rules which we have placed before your lordships. But we'll go through that again. But I deeply apologize for that. But not the by and large
The proviso is in relation
Yes.
to
Yes.
challan for a criminal offense
Yes.
ma'am.
involving, आगे पढ़ो ना,
Yes.
involving corruption or other moral defect.
Yes.
So whether this comes under these two.
I'm deeper.
Yes.
If your lordship will just see the FIR, my lords.
Yeah, I'll not see the FIR.
Yes.
I have to only
That
see
is why
whether the
I-
authority who have exercised his discretion has exercised in wisely or not.
Not letter. So not let. Yes. May I just
Yes.
not,
No, you just please conclude because we have spent more than 15 minutes.
let's say
20
yes.
minutes.
So not let us just take in this way. Take it this way. Let us not touch these rules also. But the only point is that suppose not suppose tomorrow if I received any information, I am the authority. Can I suspend him on merely on the allegations?
No, it is not allegation. He has seen the
No.
FIR also.
If I,
The allegation.
merely on the registration of FIR, I'm saying.
Maybe it is not a punishment. If you are right, you may be the
My
suspension.
lord, I may be
always
allowed
revoke.
to make my submission for
Yes,
2
yes.
minutes, my lord.
Only the point is
Yes,
suspension is
you have
not-
heard you.
Yes.
Yes.
My lord, yesterday there were only 2 grounds on which my lord had sought
The
the state to
competency
seek
of-
instructions.
yes.
One, I think my lord is satisfied
Yes,
with the
yes,
applicable
yes,
rules.
yes.
2, my lord, as far as 91B is concerned, my lord, there the discretionary powers come into play because
Yes.
the word used is may.
May.
Place a government servant under suspension where a case against him in respect of any criminal offense, my lord, does
Yes.
not make any differentiation.
Yes.
Is under investigation. So is his case is under investigation, petitioners. And the proviso deals with shall. जब चालान पेश हो गया है तब तो उसे suspend करना ही है, my lord. This is the distinction, my
First
lord.
part is the discretion of the authority.
Yes, my
He
lord.
may do it.
Yes.
91B.
The second part is mandatory when challan is paid.
Now,
He
my
cannot use his discretion.
The 2 judgments he has.
Proviso says here he is not required to use his discretion. He has to do it when a challan is invariably placed.
But may I just, may I
I have heard you.
I'll complete, my lord.
I'll
My
pass
lord,
the
the
order.
2 judgments he has referred to, my lord. The first judgment is with regards to trivial lapse, my lord, that he has read himself.
Yes,
And the
yes.
second London court judgment, my lord,
That is also very trivial.
very trivial, my lord. So there's no parity, not even with regards to
No.
jurisprudence, my lord. Here the allegations are with regards to sexual harassment
Yes,
and rape,
yes,
my
yes.
lord. And thus, my lord, the petitioner
The even
cannot
continuing
entertain.
a person against whom an allegation of sexual harassment has been, maybe it is right or wrong, but
That is
how
for
can he continue in a school?
the trial
where
court to
children are
decide, my
coming?
lord.
No.
great respect, not let us not have any preconceived
Yes.
notions since the one case is already pending.
Maybe I am not going to that.
Yes, my
We are
lord.
only saying he has used his discretion wisely because the allegation against the teacher where he is teaching is against sexual harassment.
But may I just say this only, and I will leave it to your lordship. Just 2 lines.
Yes.
Okay. First, investigation is pending. Second, that whether the suspension is automatic upon the, I leave it to your lordships upon this point only.
Yes.
Whether it is automatic or not, I am only on that.
It is not,
It is not,
it is
my
not
lord.
automatic. He has applied his mind,
Yes, my lord.
used his discretion, and then
If he has,
he
then
has to assign the reason why he
yes,
is,
where
where it is given, where it is
No,
given.
my lord.
Yes, sir. Please have the influence order, my lord.
Nay, is he required to give the reasoning also for the suspension that he has used his discretion in this?
But my lord, what parameter or what
No.
what material
Then
does he have?
show me any law where he is required, suspending authority is required to
No,
give the
but
parameters.
I can. There is no direct.
I've heard you.
Read deeply.
Right, right.
I, your lord.
Yes.